10 minutes.
Yep. Morning, Council. Thank you, Chair. Malcolm's going to come up and speak to the detail. This is really a tidy up of the Delegations Manual following some RM reforms. And Malcolm will give you the detail in 2 minutes.
Doing 636 charges. You're not reviewing. Very briefly, we have a delegations manual. Delegation can be granted by council and must be granted by council under section 34A of the RMA for staff to undertake any functions, duties where discretion is required. And that allows us basically to get on with our day-to-day business. There's a lot of decisions that we make. Basically every decision needs to have been delegated to us, and the delegations manual sets that out. There has been a change to the RMA, took effect, most recent one took effect in March this year, and wasn't sort of critical to change the delegations manual straight away, but there is a provision for 130-day processing of consents, and if we get to the end of that period, we do have to be able to make a call on whether we send that right back to the applicant and it starts again, or whether we proceed with it. And it's likely to have been on hold awaiting the applicant to give us more information, so we need to be able to exercise discretion to decide which way to go on that. And that was sort of the key thing I wanted to add to the delegations manual, but in coming back to the delegations manual, I just wanted to have a review and an update to see that it was current. It was last reviewed in April 2012. So there's just a few changes that I've identified in the report, and then I've attached the full delegations manual with tracking of changes to the back of the report. These are what I saw as a little bit more significant changes, which are and still quite minor in a sense. Some are just that the Act has subtly changed some of the provisions so that where a clause referenced a matter, it's actually the clause number has changed. So the first one is really just to reflect that change in the Act. The change to 91C2 showing here is the key one that I mentioned, that we do have to be able to make a decision at that 130-day period as to whether we suspend processing the application or we continue with it. And then there's other items such as if we notify an application or a limited notifying application, we know the specific number of parties that have been notified. If they all submit sooner than the closing date, we can actually close that period off and proceed with processing the application at our discretion. Also, there's a couple of provisions around pre-hearing meetings, and there is an ability in the Act to require parties to attend, and then if they don't attend, to actually no longer have regard to their either their submission or their application. So if an applicant doesn't actually attend the pre-hearing meeting, we can actually stop the process. So we're just looking to see that the delegation is there for us to be able to do that. It's not to say we would, and the circumstances would have to be pretty clear, but we're just asking for that delegation down to staff.
Just on that, so the circumstances would have to be they clearly didn't want to engage, or the car got a flat tyre and thanks but no thanks, you didn't turn up, so goodbye.
It would be more that they were belligerently not wanting to attend, and we made every effort to make sure they attended. If we set a pre-hearing date, and we would do quite a lot of legwork to make sure all those dates are convenient for all parties, so that then if they didn't attend without explanation, without legitimate reason, we have that opportunity, and it would be it gives us the opportunity to try and make the process work, and say you must attend, don't stay away, and if they then stay away, having set it all up and indicated they will attend and there's no reason they can't attend, we could actually use that provision.
Could I rephrase the Chair's question? What I think the Chair is asking is that before a decision is made to suspend their application or to discount their objections, that every opportunity is given to them to explain why they have not engaged. So I'm talking more here, this is more, I think what Fenton's asking is more about the natural justice rights, that you just don't make a decision without giving them the opportunity to explain. They've got a reasonable opportunity and so on. So
Yeah,
I think that's all he's asking, is that we are going to safeguard that.
Yes, well, there would be, and then there is an objection right as well. So even if we exercise that, they have a right to object to that decision, and it would come through the council or the hearings committee to actually adjudicate on that. So most of the discretion that we hold, if particularly say, for example, issuing a consent, non-notified application consent, there is a right of objection if the party's not happy with an aspect of it. But in processing consents you'll see within the delegations manual, we don't have the delegation to decline an application. We're only delegated to grant consents with conditions. So if we're, as an officer, we were minded to recommend decline, we need to set up a hearings or get the hearings committee involved so that they can make the decision, and they will see the officer's report and make a call on that. So it's only the circumstances where some of the objections might occur are because they don't like the detail of the conditions of consent. So those are really the substantive items which that I'm seeking to have amended or added to the delegations manual. Some of the other things are the fact that staff titles have changed, and there are just one or two omissions and minor improvements that we've made in the wording in the delegations manual, which you can see tracked at the back.
Just on that, if I have a look at the first page of this, which is page 17, I think it is, of our papers, and it's got the initials there of the delegated, the people who are receiving the delegations. They do not match up with the delegated to columns.
You're right.
So we have no idea when we look at this paper who we're delegating these responsibilities to. And that needs to be tidied up.
Sorry, I've corrected the names on the right hand side there, but not the abbreviation.
Which is why they don't line up.
Which is
so
why
that needs to be fixed.
So I'd ask that you direct me to correct that.
Yeah, but I don't even know. Like, for instance, PCCP, which is one of the delegated to abbreviations, does not appear anywhere on that list.
Yeah,
So I have no idea who a PCCP is.
Perhaps
And there are about 4 of them like that.
Perhaps just appreciate that it's an omission, just so we can be efficient in this. Perhaps if we could Malcolm could provide the explanation of what the changes
Who
are.
those people are, that would be
And then-
very helpful.
And then we can deal with that in the consequential changes in the document, but carry on with this process if that's all right.
That makes sense, yeah. Good spotting, Councillor
Very good.
Evan.
Yes.
So can you just want
So, other questions, Councillor Scott?
do you want us to run through the detail now?
Yeah,
So-
before we make a decision, yeah.
I don't know that that's actually tracked quite correctly in the. It should be PCP. So that's the principal consents planner.
So that's the 4th column along from the left.
And SCP is the senior consents planner. That's the next one that follows, and
Consents planner,
COP is
Consents
COP.
planner.
is the consents. Sorry, so then that should be CP, consents planner.
yeah.
Yes, it is.
And the,
I think that's all. MCS.
That's manager client services, which it says MCO. So that's wrong on the cover page.
Yeah, correct.
So that doesn't
Right
actually
there.
change.
and the cadmium measure, the next one?
We'll have to ask Molly Bendon.
And team leader operations should be TLO, Down the bottom.
TLO, I'm sorry.
You start.
TLOOEO.
So is that,
So we've got that
Sufficient.
covered.
is
Yeah,
that,
no, it's just, I mean, clearly this has to mix up, so
Yeah.
you know who we're delegating.
apologies,
Yes,
so in the
yeah.
final version, we will make it absolutely clear. We can provide you a copy of the clean version when it's
Would be great.
finished.
Yeah.
We'll circulate that.
Apologies for that.
This end of a busy year, Mr Miller will give you
Must
a
be.
little bit of leniency there. Councillor Scott.
Just a query under section 97.4. I assume that only applies during limited notification where the submitters would, the potential submitters would all be known.
Yes, we would have notified specific parties, and we would have seen submissions come in from all of them, so then we would know that everyone had submitted. Yep.
Councillor Beaver.
Yes, just this is a general query. So you're delegated these powers, and specifically, if we look at your power to determine whether an application of some sort is going to be notified, or to what degree it's going to be notified, or whether it's going to be publicly notified, and we think that's wrong, or we get matters raised with us by constituents who think that's wrong, and that's happened to me just in the past few days with regard to some transfer of a water consent where submissions have gone in, and I think I've been told responses have come back saying we're not accepting your submission because this is not going to be publicly notified. If that's the case, and we're not happy with the decision that's been made by our delegated people here, what is our right of redress? What is our opportunity to redress those matters on behalf of constituents who have got their noses out of joint because of it?
So, I mean, my advice would be that you would raise that with the CE, and she would undertake some investigation and report back to you on that. I would make the point that the consideration of notification is very clearly laid out in the Act. There's a huge amount of case law around it. The staff are very well briefed on it, so it's something they're very cognizant of and take quite some diligence around to ensure that they get it correct. That's not to say that members of the public can't object. So if there are people who feel strongly enough that council's decisions around these sorts of things are wrong, they are perfectly entitled to take or seek a judicial review and have that decision overturned. And we're always mindful of that, which is why we're very careful about the notification assessment and decisions around that, because if we're shabby and tardy, there's a risk to council of court action.
Okay, so if I understand what you've just said, and then it's a sort of a three-step process, if you like. The delegated person within our organisation here makes the initial decision. If there are concerns about that or objections to it, people can then raise that with the CE. And if they are still not satisfied, they have the opportunity to go for a judicial review. Is that correct?
Yeah, and we're more than happy to provide the explanation around our decision to any person.
Councillor Barker.
I'm going to read these documents, always read them on the basis
With the what you call?
when you read these documents, I always read them on the basis that you know nothing. And I just would like you to look at the way in which you've structured it again. See, underneath each of these things is an X. Now, there's no explanation here what X means. And see, X can mean, for one interpretation, a cross against it saying you're not, or an X could mean, the cross underneath it, that you have. And so you've created confusion here.
So we can replace that with a tick.
No, what I thought you would be better to do would actually just use the word D, and then have in the front here, D means so delegated with the authority.
We're happy to make it as accessible as we
But
can.
just
Yeah.
so you can read that and just,
Yeah.
I've
No,
had
that's-
people
that's a fair point.
argue about what an X means or doesn't mean on
Yeah.
a number of occasions. And
Yeah.
so here, it's not clear.
Okay, other questions? Someone happy to move move with the proviso that the corrections be made and we get a copy. I'm not sure that needs to be in the motion or not, but that is the obvious recorded intent of this meeting. So you're happy to move, Councillor Scott. We have a seconder for that, and thank you, Councillor Barker. Further discussion?
I'm very pleased to see this paper before us, and funnily enough, I didn't get at all confused by the table, so maybe I'm a more lateral thinker than some people. But
Well, actually, I'll call you up on that. There's no need for that, Councillor Scott.
it is good to see this tidied up, Mr Chairman, and our council actually very rarely go to a hearing on consents. The vast majority of them are done on delegation, and this is a matter of efficiency and cost efficiency to our users, and long may that record continue. So I'm glad to see this updated to reflect some of the changes of the Act to bring it in line with that.
Thank you.
Just like to say that as a lateral thinker, I have been to a number of occasions where there has been extraordinary numbers of hours argued over what X beside a name means. It's been to all sorts of courts and all people have had all sorts of arguments about it. I just think it's, from that experience, an X is not always clear, as an X marks the spot, yes I want this, or X means I don't want it. It's not clear, and I just think the simple solution we've come to here saves all the hassle, don't need people to be worrying themselves about it, what it means or doesn't mean, clarified it. And I'm very happy about that.
There was quite a
Mr.
few
Mohi.
X's on the Treaty of Waitangi as well.
That's true.
That means we disagree.
Well, thankfully, we're not discussing that today. It might take a bit longer. Further speakers? I'll put the motion. All those in favour, please say aye. Contrary, no. Carried. Morning tea for 10 minutes, please. Be back here at 1:45. Thank you.